A very good evening, everyone. I'm CA Maushmi Shah, Treasurer and Managing Committee Member at Pune branch of ICAI and the moderator for this webinar. We are delighted to welcome you all in the webinar organized by Committee on Commercial Laws, Economic Advisory and NPO Committee of ICAI. It is my pleasure to be a moderator in Know Your Law Series 54, a webinar on importance of thorough power of attorney. And before we begin, I would like to apprise you about the CCLEA and NPO committee. This committee is focused to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social value while combining analytical foresight with commercial acumen. One of the core areas of this committee is to serve the multifunctional task of analysis, knowledge dissemination, inputs to regulators on policy formulation, to develop and publish technical guidance, background materials, etc., and to create awareness for professional opportunities for chartered accountants in commercial laws, economic advisory, and NPO cooperatives. Our eminent speaker for the day will talk on importance of thorough power of attorney, a very important topic, and we hope that the same shall be useful to all the members. Before we go ahead, I would like to introduce to you the chairman of the committee, CA C.V. Chitle sir, to you. CA Chandrasekhar Chitle sir is a Central Council member. He's a BCom, LLB.
Don't introduce me. Just say that I'm chairman of the committee, that's all.
So, though you do not need any introduction, but anyways, a very warm welcome, sir.
Briefly,
and we welcome for the welcome address today.
Thank you, Maushmi. Friends, as you are aware, Commercial Law Committee looks after all the laws, excepting corporate laws and taxation laws. Power of attorney is used by professionals in various assignments. Maybe there is a person whose son is going abroad, so he may be required to look after affairs of his son, or maybe father of the person, her hands are shaky or his hands are shaky, they are not able to operate their bank account. In such circumstances, it may be necessary that a power of attorney is executed over of son, daughter, whosoever is going to operate the bank accounts or activities of such person. So for all these persons, generally, they are the taxpayers, and the chartered accountant is the lender of last resort. They are not habitual to visit lawyers, and they have continued relationship over the years with a chartered accountant. It is therefore necessary that even a chartered accountant who is attending to their activities, he is aware of this power of attorneys how they are to be prepared, what are the various things. So today we thought it fit that person who has studied it from close length, and CA Sharad Vose should enlighten us as to this particular activity of power of attorney. Maybe in 1872, some act was passed relating to power of attorneys. Though it is not exhaustive, it gives certain protection to the attorneys. That also, I believe, we will cover. And you will be glad to know that as far as this presentation is concerned, maybe we will be informed of the power of attorney. But the committee is also coming out with a booklet on power of attorneys, which will be released in the month of May. And this particular booklet will various execution of power of attorney, what are the do's, don'ts, and some practical tips. Maybe as a chartered accountant, like you are going to appear before the income tax authorities, maybe in the new avatar of this tax activities, maybe you have to represent through internet, through emails, and their emails and other documents may be uploaded from your computer system. So although you are not physically representing, maybe your e-media is being used. So tomorrow, if somebody alleges that, okay, you are not authorized to upload those documents or information on behalf of a client, I think you should also have a protection. So from that aspect, also a power of attorney draft would be prepared that, okay, you are authorizing uploading of income tax return, or maybe authorizing uploading of the replies to authorities, maybe representation before CIT appeals, ITAT. In GST realm also, you will have to appear. It is also seen that chartered accountants are engaged for the purpose of representation in mediation, arbitration, and various other activities. So if templates are available before us, maybe we can cut out that particular power of attorney to suit the occasion. So that would be the advantage of this particular booklet. Ahead of this, maybe we will be having this presentation that will give us in-depth knowledge. And you will appreciate that on this Power of Attorneys Act 1872, that became operative from 1st May 1872. So maybe 1st May 1872 can be considered as a Power of Attorney Day if we are having fashion of various days. So that can be a Power of Attorney Day. And ahead of that Power of Attorney Day, maybe it would be very useful to have presentation on Power of Attorneys from Sharad Wazir. Besides Power of Attorney, at our Commercial Laws Committee, we are also addressing various other aspects where chartered accountants can engage themselves in professional capacity. What we have seen, that as auditing, taxation is concerned, the presence of professionals in plurality is available. So in case of economics, where the supply is abundant and the demand is limited, maybe the price comes down. That's what has happened in case of maybe auditing, maybe in case of taxation. But these are the areas like maybe mediation, arbitration, labor laws, drafting of power of attorneys, agreements, the FEMA, and such other laws. There is good scope. Before goods and services tax, chartered accountants were hardly operating in the arena of indirect taxes. However, once the GST law was enacted, today 80-90% of the practitioners are chartered accountants. So what transformation GST did to indirect tax practice in case of chartered accountants, I believe that the labor laws is going to make in 2025 and onwards. What is the reason? Because today the labor laws are contained in several enactments: Payment of Bonus Act, Minimum Wages Act, Payment of Wages Act, Factories Act, and so on. So all these labor laws are contained in 4 codes. So there are 4 labor codes. And I'm not saying that they will be enacted. Today they are enacted. You will find them on website. What is pending? The pendency is only the date notified of those coming into operation. So once the date is notified, they will come into operation, and thereafter entire labor field would be governed by these labor laws. And why I'm saying chartered accountants are more suitable, because hitherto maybe it was more subjective depending upon the whims and fancies of authorities. You have to go there and do. Now the entire compliance is online and through the internet and through computers. So there is no need of a physical movement anymore. So as far as chartered accountants profession is concerned, this is the profession which is more abreast with computerized compliances, online compliances, whether electricity is there or not, site is working or not. On 29th of September, 30th of September, you will feel all the tax audit returns are getting uploaded, all the ITRs are getting uploaded. So that proficiency in this computer, internet uploading has been acquired by our profession. So it would be very easy to diversify into labor laws field, because it will not take your full-time occupation. So our committee is also coming out with the course on labor laws. So we believe that maybe in months and years to come, presence of chartered accountants in compliance of labor laws would increase. But the committee is not confining its activities only to compliance of labor laws. We are also trying to take the entire bandwidth of HR management, maybe right from recruitment, right remuneration, retention, incentive, arresting retrenchment, training to the workforce. So all these aspects we will take up, so that entire bandwidth of HR services can be provided by a chartered accountant. So this was one aspect which I thought I would bring to your notice. So the commercial committees actually our encompasses commercial laws, economic advisory, NPO, and cooperatives. For NPOs also, those who are from Maharashtra or other states, they will appreciate that there are number of limitations. A chartered accountant cannot appear before the charity commissioner for registration or other matters. When the financial statements are uploaded on website of Charity Commissioner, again they are required to be submitted physically. The format of financial statements or rules relating to financial statements, they also need complete overhauling. So in this behalf also, the committee is going to make representation so that maybe field of NPOs, field of cooperatives would be open. Today, predominantly the cooperative societies are governed by state laws, but central law is also enacted, so particularly multi-state cooperative societies, they are governed by the central enactment. For the purpose of enactment of this central law, the institute had a good role to play, and you will appreciate that once this law becomes operative, the accounting standards mandatorily are required to be followed by the cooperative societies. Audit will be more streamlined. So more things will keep on coming. So this is the entire area committee. Anyone from the audience is interested in working in supporting the initiatives of this committee, they are welcome. They can write to the committee, or maybe at Pune branch, Maushmi is there, you can inform her, or to me, you can inform, and we'll certainly take help of your energies and knowledge and expertise. With this, I once again welcome Sharad Vaze for the purpose of this presentation, and I'm happy that our committee member from Pune branch, Maushmi Shah, is coordinating this particular event. Thank you.
Thank you so much, sir, for your warm welcome to the members. And also thank you so much for letting us know the various things done at the Committee on Commercial Laws, Economic Advisory and NPO Committee of ICAI. Thanks a lot again. Now let us move ahead. I take this opportunity to introduce our speaker for the day, CA Sharad Vaze sir. Sharad Vaze sir is a fellow member of ICAI, practicing for more than 41 years and a senior partner in Sharad Vaze and Company, Pune. Besides his post-graduation in commerce, he has also done his LLB and is also a graduate member of Institute of Cost Accountants of India. He was the managing committee member of Pune branch of ICAI during 88 to 91, and he was the chairman of Pune branch in the year 1991. He is the founder member and a life member of Pune Chartered Accountant Society. He has written many articles on taxation, company law, banking, etc., which were published in Economic Times, Taxman, Daily Sakal, etc. He had written weekly replies in Marathi on taxation issues asked by general public in Daily Sakal. He has been a faculty to various seminars conducted by ICAI at branches, regional councils, peer review board, ICSI, and colleges as well. He loves teaching. As such, he retired as an associate professor from BMCC College at Pune after 35 years, teaching costing and taxation. He has authored 3 books on auditing, taxation, costing for last year BCom students of Pune University. He has been the visiting faculty to National Insurance Academy, Symbiosis Institute. He regularly represents assessees and income tax appellate tribunals, member of ITAT Pune Bar. He has been the counsel to more than 100 chartered accountants for their cases before disciplinary committee of ICAI and the appellate authority. His experience in such cases as a counselor has made a series of 30 lectures which were published every week in 2021 on YouTube channel titled as Sharad Vaze on Professional Misconduct. So a warm welcome to you all, and we are all eager to listen to you. Over to you, sir.
At the outset, I thank Shri Shekhar Chitre, my friend, who has given the opportunity to speak before you on the power of attorney, its usefulness, its necessity, and the contents thereof. Now, we are using power of attorney almost in our day-to-day professional practice, and especially with respect to the representation before the income tax authorities. Now, what is the contents? What are the formats? When it is required? What is the stamp duty required? All these details I'll be speaking in next 1 and 1.5 hours. So, power of attorney is a legal document that allows someone else to act on your behalf. That is a simple definition. The thing which want to do, but is not in a position to do it, you are allowing other person to do it, that the authority which you are giving to other person to represent you, that authority is a legal document, is called a power of attorney. So power of attorney not to be considered as something new to the legal system. In fact, it originates from the days of Ramayana. Now, the Angad, who was the son of Vali, was sent as emissary by Lord Rama to the king Ravan. And the Lord Ram had given power to Angad to represent him before the king. Moral power of attorney bestowed on Angad by Lord Ram. In a sense, he was asked to make a final representation before the king Ravan that you release honorably the Sita Devi and end the war between that may ensure thereafter. So this was the representation made by Angad on behalf of Lord Ram before the king Ravana. Now that practice of representation continued even in Mahabharata. We are aware that Lord Sri Krishna had visited the court of Duryodhana, asking him that you can give one village for all the Pandavas, and that will end the enmity between Kauravas and Pandavas. At that time, Duryodhana said that I will not give even 1 millimeter of the land to them, and he rejected representation. So here also, Lord Sri Krishna was representing Kauravas before the Duryodhana. So this is also kind of power of attorney given by these persons, Lord Rama to Angad or by Pandavas to Sri Krishna, to represent their views before the other persons, that is to speak on their behalf. However, at that time, probably the written documentation may not be required because the people were honest. And if one says that, if Angad says that I have been sent by Ram, or if the Sri Krishna says that I have been sent by Pandavas, no one objected to it, or no one asked for what is the letter of authority or the power of attorney to represent those persons. Because that was generally we consider as a satyug, so it was the honest people living at that time. Now, why a power of attorney is required? A power of attorney is required when you choose a person to act on your behalf in your absence. It's a simple statement. Power of attorney is required to act on your behalf in your absence. And there can be many situations. You may not be present, or even if you are present, you wanted the expertise of other professionals. For example, if there is an assessment for the income tax authorities or the GST, or if the appeal is the CIT or tribunal, then as an assessee can attend before the assessing officer, can attend before the CIT appeal, maybe online, or even physically attend before the tribunal, can present his own case, but may not be, he's expert in the laws, that is taxation law, so he prefers. Is it audible? He prefers
Yes,
that
sir.
a professional like chartered accountant should represent the assessee because he has expertise in the subject and he can represent the case before the tribunal in a proper manner or the manner it is required by the tribunal. So here also, even if you are present, you are giving power of attorney to someone else. It is not necessary that in your absence only power of attorney is required. A power of attorney is also required even in your whenever you are present. Many times we have seen in the tribunal, the assessee does attend the hearing also, but nonetheless, the chartered accountant argues the case on the basis of power of attorney given by the concerned assessee. So there can be many situations where you may not be present, or even if when you are present, yet you wanted to be properly represented before the courts, tribunals by a knowledgeable person. Now, a power of attorney can be given in your good times for any eventuality in future. Probably, suppose a person at the age of 70 is in a position to sign the checks, but it does happen many times, especially after 65, 70 onwards, the two signatures rarely match, or the signatures which is at the bank records rarely tallies, and the bank manager, the bank officer asks you to be present in the bank and to sign in his presence. So even if there is a small variation, he accepts it, probably because the bank person knows you since you're having account with them. But many times it so happens that the person, his hands have become shaky, or he's suffering from diseases like Alzheimer, etc. In that case, it is preferable to have a power of attorney. Even if you are in good position, you are in a good physical health, you can give the power of attorney to a near relative to operate bank accounts or to do such other acts which are legally required to be done by you, can be done by such attorney on your behalf. Or even there can be a situation where you meet with an accident, and suppose you are a right-hander and your right hand has fractured, or there is a multiple fractures because of which you have to undergo surgery, and you are not allowed to use, or you cannot use, rather than not allowed to, you cannot use your right hand for about say 3 to 4 months. Now, in that situations, then how do you operate your bank account? Then you can still operate the bank account by giving a power of attorney to the banks, or to general power of attorney, which will include the situations or the things which you could not do it because of your right hand affected. And in such situations, you can do power of attorney to near relatives, maybe for signing the balance sheets, maybe for uploading the tax returns or signing the tax returns. That means for we are operating a bank account, all these things are possible by giving a power of attorney in these situations. Now, the question might be, if my right hand is not working or is not in a position to sign, then how do we give the power of attorney? Generally, in practice, such power of attorneys are registered power of attorneys. In that case, at the time of registration, you can use your thumb to give the power of attorney, and based upon that, the donee can act, the donee can work on your behalf. Now, who is the donee? I just referred the word donee. A person giving the authority is called a donor, and a person receiving the authority is called a donee. I think these words you are aware of it, which we referred under the gift tax. The person making the gift is a donor, and the person receiving the gift is a donee. So similarly, if a person is giving the authority, he is called donor, and a person in whose name the authority is given is called donee, or is also called commonly attorney. Now, what are the situations that might arise? I have listed out about 7-8 situations we'll discuss with one by one. The power of attorney to represent before the courts, tribunals, or other quasi-judicial authorities. Here, the donor of the attorney is availing the expertise and professional knowledge of the donee attorney. I have just given the example of, even if you are physically present, it is preferable to give power of attorney in the name of a professional like chartered accountants, who can represent in better manner before the appellate authorities in case of taxation issues, maybe direct taxes or indirect taxes, because such person has got substantial expertise in the respective profession, in the respective laws. Now, the power of attorney is required when physically you are attending before the courts, tribunals, etc. In fact, unless you submit the power of attorney before the tribunal, you are not allowed to stand to represent the assessee at all in the courtroom. But even in case of virtual hearing, which is taking place nowadays in the tribunals also or at the courts also, even if the hearing is virtual, still you are required to have a power of attorney, and that power of attorney can be submitted or uploaded. I think you may be aware that under the income tax, there is if you are representing your assessee for the appellate CIT appeal, then there is a provision or there is a button to admit or represent you then that button is activated. Then you have to tell the name of the person, and as an enclosure, you have to attach the power of attorney, and thereafter the power of attorney, then that authority is accepted by the income tax authorities or NFAC, whatever the case may be. So in the virtual hearing, a power of attorney is required. In short, if you want to represent a person, you require a power of attorney. The power of attorney is required is normally given in favor of parents when their children go abroad for employment or education. It happens graduation, post-graduation, like BME or even chartered accountant who go abroad for pursuing the MS degree or MBA degree in finance, etc. Now they are supposed to be there for minimum of 2 years, and thereafter they are allowed to work there for 1 year. So normally 3 years they are out of India. In that situations, the power is given by the children to their parents to operate their bank account, and if the bank account has got balances, then to keep the money invested into fixed deposits, or they can also invest in shares or mutual funds. That means if he would have been present in India, what he would have done, all those things can be done by the attorney holder, that is by the donee. Even the returns are required to be filed, returns can be filed, a refund can be claimed, and if required, an appeal is to be preferred, then appeal can also be filed on behalf of the child to the appellate authorities. So where the time duration is 3 years or more, 2 years or more, even if it is for 6 months or 8 months, doesn't matter. The power of attorney will help you to do any act or things that would have been done by the donor can be done by the donee. The third situation is power of attorney in favor of spouse by those persons working abroad. We have seen that there are many persons who are employed outside India and their families are in India. Every month they are remitting money for their maintenance or for their day-to-day expenses. Besides, in such situations, the spouse who is working abroad may require to give power of attorney to the another spouse or other spouse in India, obviously to do any act or thing that would have been done by the employed person outside India, like operation of bank accounts or operation of any other demat account or signing of income tax returns and so on and so forth. But in the case of children, normally the period is 2 to 3 years, whereas in the case of persons who are abroad, the period may be quite longer, or there may not be sunset clause in the power of attorney. It will be forever until it is withdrawn. Then power of attorney is also required. There are many non-resident Indians who have got properties in India. Now, there are situations like this. Non-resident Indians, maybe anywhere in the world, they have purchased the property, immovable property in India, maybe a flat. Normally, they purchase the flat because it is much secured than the open plot or a bungalow. Now, they have purchased from their own funds, which they have earned over there outside India. They remit to India, and they purchase the properties. Or the properties were acquired or purchased by their parents, and after the unfortunate demise of their parents, now the children who are non-residents, now they have become the owner of such properties. It is quite likely that after a few years, or maybe the non-residents have acquired citizenship, their children are also staying there, and they do not want to, or they don't want to return to India, or there is very unlikelihood of coming to India, and in such situations, they want to dispose of the property. Now, whenever they want to dispose of the property, of course, any transaction with immovable property, the document must be registered. That is the requirement of Section 17(1) of the Indian Registration Act. So in that case, they have to be physically present for the transfer of their immovable property situate in India. But practically, it is not possible because they hardly get a time to not more than 10-15 days. And in those 10-15 days, it is very difficult to find a buyer, negotiate with him, and then execute a document. So in such situations, they give power of attorney to their near relatives, and based upon that power of attorney, a property can be sold, and the donee or the attorney can accept money or consideration on the transfer of such property. So this is very common nowadays, where the non-residents are intending to sell their property, and it may not be possible all the time to come to India, or it is expensive also, it is time consuming also, so they prefer to give power of attorney. We'll be seeing later on how to execute a power of attorney outside India in due course of time. Then the power of attorney may be required in case of a near relative due to his physical incapacity of a donor. In the examples or templates which are given to the committee, Commercial Laws Committee for ultimate publication, there it's a situation where a lady is there and her husband is almost on vegetative state for last 10 years. She's not in the anything at all. In that case, he has given the power of attorney in the name of his wife because he is suffering from some diseases which does not allow him to get down even from the bed, and he is lying there for last 10 years. Thus, there can be n number of situations where we have to visualize in a sense where you are not in a position to do, you want to get it done, then you can give power of attorney to another person to get the things done on your behalf. Now, one more aspect which has been raised by our CCM, which I'd like to answer that, whether power of attorney is required to file income tax returns and GST returns. The answer I can give may be yes or no, depending upon the situations. Now, what happens in case of returns or GST returns? Suppose the client comes to me, I get the detailed information, whatever is required for filing tax return. I upload the tax return from my laptop or from my computer, which has got a specific IP address, and the OTP, one-time password, Aadhaar link one-time password, goes to the assessee or to the person whose mobile number is registered in the income tax website. Now you can ask the person over the phone or by sending the SMS, etc., what is the OTP, and you enter the OTP, and then the return is accepted. Now, why these two stages are there? Because once you have got the login ID and password, you can open the his income tax account, and you can file the return of income with imaginary figures, and ultimately the assessee will suffer. So it should not be like that. One should not abuse or misuse the authority. So in that case, the assessee has been given a choice to authenticate the return, to accept the return, or to approve the return by submitting OTP or through your net banking or through your ATM. There are various modes that has been prescribed under the income tax. Now, in this case, if a client comes to you, you upload the return and he gives the OTP to you, then the return is accepted. In my opinion, in such situations, the authority or the power of attorney may not be required. It is preferable, it is better to have it. However, if you are aware that your client is not in your place, that is is somewhere else or he is abroad, then he can very well say that the return was uploaded by the chartered accountant without consulting me, and he has approved it. Maybe even my OTP, but I was really not aware what has been uploaded, because what I get is the OTP only. I do not get the entire computation of it in the return of income, because in the return of income we get that particular item 3, 4, or whatever the case may be. So in these cases, if you are sure that the concerned client is not at the place at which you are practicing, then it is preferable to have the power of attorney. But if he is in the city in which you are practicing, you may very well say that the concerned client was before me when I uploaded the return of income, and he gave the OTP. So normally in my office, I have a practice of sending the computation of income, final return of computation to the SCC, and I insist that email back to me that the computation is okay, you can upload it. When he says that on the telephone that it is okay, you upload it, I insist that you send back to me a reply to my email that the computation is okay, you can upload it. That makes difference. That means in that case, you are uploading the return as if he is doing it from your laptop, then it will be easier one. There will be no dispute or references to the professional misconduct cases. However, if you are filing the return of income on behalf of non-resident, then I would advise you to have a power of attorney in hand, because later on he should not say that I do not have what has been uploaded, or it has been uploaded by my chartered accountant and for its IP address is available. It can it was filed by me, but it was filed by chartered accountant, and that's why he should be held. But disputes, it is to have power of attorney for filing income tax returns. The same is equally applicable for GST returns also. Now, one more aspect in these situations need to be discussed. That is regarding the use of digital signature certificates. Practically,
Hello. I think sir's voice is not audible.
is it okay?
Sir, now we can hear you.
Yeah. Now, those who are practicing, they are aware that we are holding many DACs of our clients. It has been used for income tax return validation. It is used for GST returns. It is also used for filing of various ROC returns. Now, technically, DAC is a private property of your client, which you are using it, maybe albeit for him, but it is better to have a power of attorney that he has given you digital signature certificate for use for application on income tax or GST returns or ROC filings, because there might be a situation where the concerned client may disregard the application of DAC to the document that has been uploaded. Now, recently, about a month or two back, I had occasion to deal with this issue with a professional misconduct case where the client has alleged that, as usual, there is a dispute between two directors, and one director has alleged that my signature, my DSC was misused by chartered accountant for uploading third person as an additional director. See, A and B are two existing directors, and son of A wants to be admitted, to which B has objected, but B's DSC was being used for ROC returns. Now the concerned chartered accountant was having the B's DSC, and with the help of B's DSC, he has uploaded the his DSC was used. Now he filed a complaint with the institute that without my consent, without my specific authority to use my DSC for uploading this particular form is a professional misconduct. And mind you, the committee accountant guilty for professional misconduct. Because when the issue was being discussed, the committee simply asked where you have an authority to use his DSC on this particular form. So it is preferable to have the authority from your clients power of attorney is also required for handling or use of DSCs, digital signature certificates, on behalf of your clients. And the next issue is regarding the stamp duty. Whether DSC power of attorney requires a stamp duty, the answer is yes, but it is subject to. In a sense, the stamp duty is a state subject. The stamp duty applicable for power of attorney may vary from state to state. Just to give an example, if you want to execute a power of attorney in Maharashtra, you require a stamp paper of rupees 500. However, for execution of power of attorney in the state of Madhya Pradesh, the power of attorney is required to be executed on 1000 rupees stamp paper. That means the power of attorney varies from state to state. It is better to have the knowledge about, or you can get the knowledge locally from your state, what is the amount that is required for the execution of power of attorney. However, there are certain regulations, especially in Maharashtra, where power of attorney is given, which allows you to transfer a property, then the stamp duty as applicable to a conveyance is required to be paid on the power of attorney. I'll give an example why this has arisen. Suppose A wants to sell a power of attorney for rupees 1 crore and B wants to purchase it. Now, B has paid 1 crore to A and A has given power of attorney to B that whenever in future B can get the property in his name, or even B can sell the property on the strength of this power of attorney to C or D or any other person. Now, that was the practice some 25, 30 years back in Maharashtra. Now, what has resulted into that A has sold the property, he got 1 crore rupees. B got the possession of the property, but in the process, no conveyance was executed because B was having the power of attorney of A, the seller. So the government did not receive the stamp duty applicable to conveyance. Even the matter was not getting reported to income tax authorities because the transfer had not taken place. Now, to circumvent these situations, the laws were amended. Under the Income Tax Act, we have got the transfer has been, definition has been included such situations, that is number one. And in the state of Maharashtra, if power of attorney is given for a consideration of receipt of 1 crore, then that power of attorney shall bear the stamp duty applicable to conveyance. Now, for instance, in Maharashtra or in Pune, for a transfer of immovable property of rupees 1 crore, you have to pay rupees 7 lakh as stamp duty. That means A can give power of attorney to B by paying 7 lakh rupees stamp duty. That means the power of attorney will be executed on stamp paper worth 7 lakh rupees. Then it is an acceptable power of attorney, which otherwise would have been on rupees 500. That means if the intention of giving the power of attorney is to give power to purchase the property or to sell the property to any other person, then it will attract the stamp duty as applicable to a conveyance. Probably similar situation or similar provision may exist in other states also. Frankly speaking, I am not aware of it, but most of the states does have these provisions. However, in Maharashtra, if power of attorney is given to a relative for transfer of property, then it can be executed on 500 rupees stamp paper. The term is relative is defined like father, mother, brother, sister, wife, husband, son, grandson, granddaughter, father, mother, brother, or sister of spouse, etc. That means these are the near relatives. If you give a power of attorney for allowing them to transfer the property, then it can be executed in the name or rupees 500. Otherwise, the stamp duty as applicable to the conveyance is payable. Of course, this is repeat again, this is applicable in the state of Maharashtra only. Other states may have similar provisions because in this way, the government has lost the revenue and have amended the stamp acts accordingly. Even the advocates are required to pay the stamp duty by way of affixing a court fee stamp on their wakalatnama. Wakalatnama is again a sort of a power of attorney where they affix a court fee stamp, whereas because it has been so provided under the Advocates Act, for a chartered accountant like us, we have to get the power of attorney on a stamp paper of the appropriate stamp duty. Now, whether power of attorney requires any witness, the answer is no. However, if the power of attorney is required to be registered, then naturally it requires witness. Because generally registration is not required to represent the courts, the income tax authorities or appellate authorities or other arbitration tribunals, etc. You do not require a registered power of attorney. However, if the content of the power of attorney is allowing the donee or attorney to transfer the property or to deal with that property, then the power of attorney must be registered. I'll just read out. If a power of attorney authorizes the donee which purport or operate to create, declare, assign, limit, or extinguish, whether in present or future, any right, interest, whether vested or contingent, of the value of rupees 100 rupees or upwards, to or in an immovable property, such power of attorney needs to be registered. In short, we used to say that any transactions involving immovable property, the document must be registered. By virtue of power of attorney, if you intend to create, declare, assign, limit, or extinguish, that means even if you want to give the property on the rent, that is, it is a transaction involving immovable property, then such power of attorney must be registered because it has been so provided in section 17 subsection 1 clause B of Indian Registration Act 1908. And that clause B had made a provision that the value of the immovable property should be rupees 100 or more. All of us are aware that nothing, you can get even a 1 square feet or even 1 square inch in 100 rupees. This 100 rupees limit is prescribed by 1900 Act, and in 1900 Act, 100 rupees has a value. Even in 2024, the value is the same. So virtually, in case of every transaction relating to a immovable property or involving an immovable property, the power of attorney must be registered. It may be for transfer, it may be for purchase, or renting out the property on behalf of the of a donor, like name, son, daughter of, that is description, Mr. X, son of Y, likewise, address, and age of the donor. If you are not aware about the age of the donor exactly, you have to write at least the word adult. Because power of attorney is a contract
Sir, can't hear you. Yes. Hello. Acha. So he's joining back? I think sir will join back. Let's wait for a minute.
Maushami?
Yes, sir, we can hear you now. Hello. Hello. Hello.
Shall I continue?
Yes, sir.
Yeah. One minute. Yeah. So where you have to give the description of donor or a partnership firm or a trust, then you have to state that A, partner of Messrs ABC, comma, adult or age, residing at so and so place, do hereby give a power of attorney to chartered accountant XYZ, like that. That means if a power of attorney is given on behalf of another entity, not on your behalf individually, then you have to describe the capacity in which you are giving the power. That means either as a director of a company, XYZ Private Limited, or partner of a partnership firm, Messrs ABC, or say Dwarika Trust, as a trustee of that Dwarika Trust. That means whatever the case may be, when you are giving power on behalf of clause A. The purpose may be to represent before the tax authorities. So purpose and objectives both are to be. This includes a long list of various powers bestowed on the donee, like operating a bank account, signing of income tax return, filing of appeals, appointing concern. That means you can have 10, 15, 20 want to give power to the donee can include it. This is called authorization or the objects clause. The third content normally is This clause helps the donee to submit any evidence or information suitable to his pleadings before the courts or tribunal. Even such production of evidence may be necessary in case of KYC documents periodically to banks. So we do include production of evidence by the donee on behalf of donor before the courts. Or if you have got a bank account and you're not in India and your account is blocked because non-submission of KYC or re-KYC documentation, and in that case, if you approach the bank that my son is abroad and these are his PAN numbers and Aadhaar numbers, so kindly activate the bank account. The bank will naturally ask for the signature self-attestation. In that case, you cannot self-attest your son's PAN or Aadhaar number because the word self implies the person whose PAN is there, whose Aadhaar is there, he only can attest it, no other person. But if you have got the power of attorney, then you can put the signature and can write below Mr. XYZ, power of attorney holder for ABC, then the bank will accept it. That is, production of evidence is to be allowed by the donor to the donee. This is also one of the contents. Then many times the attorney, power of attorney also gives you power to sign on behalf of the donor. Suppose a document is to be submitted, then the court will ask for the signature. As I just given the example earlier, the bank asked for self-attestation of the account holder, and you are not the account holder, then you cannot sign it. But if the power of attorney allows you to sign any documents as an evidence to be given to the courts or to the banks or such other institutions, then you can sign on behalf of the attorney, on behalf of the donor, and the matter will be resolved. Now, this will be required even for signing the rent agreement, signing of tax returns, and so on. Now, this is not only restricted to production of evidence, even otherwise also, wherever the signature of donor is required, and if you give the power to sign on behalf of the donee, on behalf of the donor, donee can sign the document. The next content is normally of receipt of notices. When the notice is issued to the a taxpayer on assessee, and if you have got authority to receive the notice on behalf of the assessee, then and then only the notice will be treated as properly served. If you do not have power of attorney, if you do not have authority, and if you still accept the notice, and later on there is a problem with the relationship with your client, then client can say that I have not given the authority to accept the notice, and therefore the notice has been accepted by my chartered accountant without authority. He has accepted the assessment order without my authority, and there is a delay in filing the appeal. The chartered accountant is professionally negligent. But if a chartered accountant in his power of attorney has the authority to receive assessment orders, to receive notices, then obviously this charge will not be there in the name of negligence. And normally we do have a residuary clause because we cannot visualize everything and we cannot have power of attorney for each and every clause which comes to my notice now and then. So we include a residuary clause which reads like this: the authority to bind the donor by the acts of donee can never exceed the authority given to him. For instance, an authority is given to donee to operate a bank account. However, this authority will not help him to e-verify the income tax return through net banking. Donee must function within the parameters of authority bestowed upon him. So donee cannot assume the authority on behalf of donor has been given to him, what has been authorized to him, only within those four corners he can act. Now, in these cases, we state that the acts done by the D shall be binding on me if I were there. So the next content is acts of donee to bind the donor. Any act done by the donee in persons of power of attorney, but within the powers granted by the donor, shall be binding on him. So what is important? The acts of donee shall be binding on the donor, provided they are within the powers given to him by the donor. If the donee has exceeded his powers, then the acts of the donee are not binding on the donor. Then obviously it states, next content is date of execution. The power of attorney shall state the date of execution as well as commencement of its life. The power of attorney may provide a sunset clause either by date or by completion of event. That means there can be a sunset clause. That means if I give a power of attorney from today, then I am authorized to work on behalf of the donor. But if the power of attorney states that this attorney shall be valid up to 31st March 2025, then automatically it will lapse on 1st April 2025. So it is a sunset clause by period. Or if the power of attorney states for a particular event, that means to represent his case before the Income Tax Appellate Tribunal. So once the hearing is concluded, once the order is passed, the power of attorney comes to an end. But if these two things are not there, that means if there is no sunset clause, then power of attorney is continuing unless it is withdrawn. Then signature of donor, next content. The donor shall put his signature to give the authority. He must state the capacity in which he is signing. He may sign as an individual or as a partner, a firm, director of a company, trustee of a trust, whatever the case may be. He should sign on behalf of other person, then he should have the requisite authority. So he should ensure that, the donor should ensure that the donor has authority to give such power by their instrument. That means if the authority is given by a partner, then the partnership deed must authorize the donor to give power of attorney to another person. Or if the director is giving a power of attorney, then it should be supported by a board resolution. Then only the director can give the power of attorney. But of course, all these things the donee need not take into possession. He has to presume that these things does exist and actually he can act upon it. But the responsibility is of the donor to ensure that he has adequate power to give the power of attorney or to issue the power of attorney in the name of another person. Then acceptance and signature by a donee. Giving the power of attorney to donee is not a unilateral act. The donee must accept the authority given by the donor by putting his signature. That's why we do write, I accept, and I put my signature. So two things are there. I'm accepting the power, and in token of that acceptance, I'm signing a document. Now, one issue is, can delegator delegate further? That means if A has the power of it, if suppose A is a non-resident, he has given power of attorney to his father B to file the income tax return, and accordingly B has filed income tax return. However, there were some additions made in the intimation under 143(1)(a), and the father wants to file the appeal. And in such situation, father approaches you to file the appeal. You can file the appeal on behalf of father. It can be e-verified also by him, provided it has been so authorized by A. That is the responsibility of A, not concerned at all. However, if father wants to give a power of attorney to C, a chartered accountant, to represent. Now, whether father can give further power of attorney to C to act on behalf of A, that is called delegation of further delegation. Now, it is possible that if A has given power of attorney to B, and the power of attorney given to B includes a clause allowing him to give power to C to represent A, then B can validly appoint C to represent A. This has been so provided by Section 2 of Powers of Attorney Act 1882. In fact, whenever I have a discussion on this particular issue with various my professional friends, almost 90% of the were not aware that there exists such powers of.
Is there any problem with the connectivity?
I don't know. I just getting download. I'm using my hotspot, mobile hotspot, because I'm out of Pune now.
Now we can
In
hear
the
you.
ban.
Continue.
Shall I continue? Yeah.
Yes.
So we'll come to this Power of Attorney Act after the end. Then execution of power of attorney outside India. This is most crucial nowadays. A person need not be in India to give power of attorney. If such person desiring to give the power, what is the way out? Should visit Indian High Commission or Indian Embassy or its sub-offices like consulates. The concerned person will have to execute the power of attorney in the presence of consular officer who countersigns as a token stating that the executant has signed before him. This is called normal attestation. So there are two ways in which you can execute a power of attorney outside India. One is apostille. India has been a member of Hague Convention dated 5th August 1961. India became a member of this Hague Convention in 2005 that abolished the requirement of legalization of foreign public documents. Apostille is acceptable in all member countries of the convention. Apostille is done for personal documents like birth, death, marriage certificates, affidavits, powers of attorney, educational documents like degree, diploma, matriculation, secondary level certificates, etc. As India is a member of the Hague Apostille Convention, no further attestation or legalization of a document apostilled by a member country should be required for such apostille document in India. An apostille document should, however, be treated as legalized document for all purposes in India by all concerned in accordance with the international obligation under the Hague Convention. So where it is apostilled by in the local country, and otherwise if the country is not a member of Hague Convention, then you have to go for normal attestation. Now in that case, you have to approach the Indian High Commission abroad or Indian Embassy outside India. Now there is a difference between High Commission and Embassy. Wherever the Indian representative in Commonwealth countries is there, his office is known as High Commission. That means we have got High Commission in UK, we have got High Commission in Australia, we have got High Commission in New Zealand, like that, because these are all Commonwealth countries. But Indian offices, Indian government offices other than Commonwealth countries are called embassies. That means in USA, we have got Indian Embassy. In Canada, we have got Indian High Commission. So that is a small difference, but it doesn't make any difference to us. The concerned person has to visit the Indian Embassy, Indian High Commission, or large countries like USA. There are consulates at other places also, because commission or embassies are in the capital cities only. So if Indian Embassy is in Washington, DC, then at other places like Houston, like Chicago, like San Francisco, there are Indian consulates. So even if you can go there, can get the execution of power of attorney. Now there you have to visit there. Now you need not be Indian citizen. You need not be Indian person of Indian origin. Even a foreigner who wants to give any document to be acceptable in India, he can approach the Indian office over there and can execute the document. I'll just read out what is done by the consulate in such situations. What the consular officer says, I'll just read out. Signed before me by ABC, person unknown to me, but who has produced US passport number, the country passport, issued at so and so place on so and so date as the consulate does not responsibility about the contents of the document. Legalization done on legalization number, date, and below seal of the consular officer of the, say, New York or Chicago or San Francisco. That means you need not be Indian citizen to visit Indian consulate over there. An American can visit Indian consulate, present them the document where you want to sign it, and you have to inform that the document is being used in India. That's why I have approached you. Then you can sign in their presence. It will be countersigned by the consular officer. Then that power of attorney can be sent to India, and that will be a valid document. Now this power or authority for attestation is provided by Section 3 of Diplomatic and Consular Officers Oaths and Fees Act 1948. There is a provision for such act in 1948. Now, I have been referring to a Power of Attorney Act. It was passed in 1882, the Powers of Attorney Act 1882. It has got only 6 sections, 6 smallest act I can say. It came into force on 24th February 1882. It extends to the whole of India. Now, the definition section 1A says power of attorney includes any instrument empowering a specified person to act for or in the name of person executing it. That is the definition given in subsection 1 in section 1A of the Powers of Attorney Act. Now, but if you look at the Power of Attorney Act, it has some funny provisions, so to say. So that is the difference between theory and practice. Section 4 of the Powers of Attorney Act, subsection A, reads like this. An instrument creating a power of attorney, its execution being verified by affidavit, statutory declaration, or other sufficient evidence with the affidavit or declaration, if any, be deposited in the High Court within the limits of whose jurisdiction the instrument may be. That means if you want to give up, A wants to give a power of attorney to B, then A must submit the copy original power of attorney in the High Court or in the District Court, and that is supported by an affidavit. This is the theory. In practice, we are aware, and if you approach the District Court or if you approach the High Court, probably they will not know that there exists such provision in the Powers of Attorney Act. Then it has been provided in clause B that a separate file of instruments so deposited shall be kept by the High Court or the District Court, and any person may search the file, inspect every instrument so deposited. That means it was possible in 1882 and certainly not possible in 2024, where lakhs of powers of attorneys are being given or issued throughout India, and if they are to be deposited in the High Court or the District Court, a separate person will be required or a separate office will have to be created for the keeping and maintaining these powers of attorneys. So it is in the law only, never or not in practice as of today. The next section is even more funnier. Section 5, I'll just read out. Power of attorney of married women. A married woman of full age shall, by virtue of this act, have power as if she were unmarried by a non-testamentary instrument to appoint an attorney on her behalf for the purpose of executing any non-testamentary instrument or doing any other act which she might herself or to do. Creating of attorney shall apply thereto. That means there was a special provision validating powers of attorney issued by married women. Now that was the position in 1882. Needless to say now, what is the situation? So it is there in law only and not in practice. Every day we do get powers of attorney being executed by married or unmarried women. It doesn't matter. Now, in the booklet which is being published, I have attached about 8 or 9 specimens. The whole idea of this webinar, as I understand, is this: after this webinar, your specific queries will be taken care of in that booklet. Or if you want to have a power of attorney for a specific occasion or for a specific event, then you can ask for it. The committee, while publishing it, will include, or if you can send a draft to the CCLEA, then we'll consider it, we'll include it, so that the booklet that will be published by Commercial Laws Committee will be thorough, in a sense, will be complete in itself. That was the whole idea in holding the webinar. Now, that is what I wanted to say from my end. If there are any queries or doubts, if any questions are to be raised, you can raise it now. I'll try my best to reply, because I'm not an advocate, I'm a practicing chartered accountant. So my knowledge is very much limited to my professional activity as a chartered accountant. And that's why in the booklet, we are not included the power of attorney for which is included in joint development agreement, because they are the powers of attorney for specific situations and not the power of attorney normally required by a professional chartered. Motion.
Do we have any
Yeah,
questions
any
from the
queries are there?
So we have a query. What is the effect of death?
Effect of, what is the effect of death?
Yes.
See, power of attorney basically is I am allowing another person to act on my behalf. A is allowing B to act on behalf of A. So if A is no more, the power of attorney will lapse. After death of A, B cannot use the power of attorney to do anything on behalf of A. However, there is an exception, again, that has been provided for with reference to Maharashtra Stamp Act 1950, where the power of attorney is executed as if it is a conveyance. Given the example earlier that A wants to sell the property to B for 1 crore and is giving the power of attorney to B, and the document is not registered. If this document of 1 crore is executed on a stamp paper worth rupees 7 lakhs, the stamp duty as applicable as a conveyance on the transfer of 1 crore property is paid on the power of attorney, then such power of attorney is called irrevocable power of attorney, and even after the death of A, B can act upon it and can do qua the transfer of the property or whatever is included within the 4 corners of authority given to him, not beyond that. Otherwise, if there is a normal power of attorney to operate a bank account, to file income tax return, to sign or to represent the assessee before the appellate authorities, etc., in the event of death of the donor, the power of attorney lapses. It is no more usable.
So this query continues. Whether documents created with power of attorney on death of a person are valid.
Loudly again.
Whether the documents created
Your voice is cracking. I could not hear you. Hello?
Can you hear me, sir?
I could not hear you.
Can you hear me? Hello.
There is a chat box to here.
So we have another question. Should I take that?
Yeah.
Does law of limitation apply on power of attorney? Should we get the power of attorney signed again after the expiry of 3 years from the earlier power of attorney? Could you hear me, sir?
Is it possible to type in the chat box? Is it possible to
Sir,
chat? Can you type?
You can try switching off your video. Probably the internet connectivity would be better.
I think.
Am I audible, sir?
Yeah, it is audible, but when you speak out,
The question is, does law of limitation apply on power of attorney? Hello?
hello.
Sir, does the law of limitation apply on power of attorney?
Law of limitation. Moshimi, can you type it over
Does
there?
the power of attorney expire after 3 years? Okay, okay, sir, I will. So I've sent the query.
Does the law of limitations apply to power of attorney? See, the law of limitation is if you are, as I told you in the speech earlier, you can have power of attorney with a sunset clause by date that the power of attorney shall expire on 31st March 24, then it shall expire on 31st March 24. On 1st April 24, you will have no authority because the power of attorney is already expired. That is one situation. Second situation, it can be event. That means the power of attorney is given to represent an assessee before the Income Tax Appellate Tribunal, and after the hearing is concluded, order is passed, then after the conclusion of that event, the power of attorney gets expired automatically. But if there is no provision or if there is no specific mention for the period or the event, then the power of attorney will continue till it is revoked or cancelled or withdrawn. So the question of depends upon the limitation in a sense what is provided in the power. See, power of attorney is basically an authority to do something on my behalf. So it is for me to decide whether it will be forever or for a period or for an event. But that should be included in the power of attorney.
Okay, correct. So another question, power of attorney is notarized by agencies such as FedEx, banks, etc. Is this valid? Should power of attorney be notarized only by the embassy?
See, where outside India, then it has to be executed by in the consulate only because of that specific statute referred to Diplomatic and Consular Officers Oaths and Fees Act 1948. That is an act of Indian Dominion, Indian government. So you have to follow the act. And the relevant authority is given in section 3. I'll just read out 3. Every diplomatic or consular officer may, in any foreign country or place where he is exercising his functions, administer any oath and take any affidavit and also do any notarial act which any notary public may do within a state mean India, and every oath, affidavit and notarial act administered, sworn or done by or before any such person shall be as effectual as if duly administered, sworn or done by or before any lawful authority in the state. That means wherever a document requires notarization, and if you do it before the consular officer, then it will be deemed as if it has been done before the notary in India. So any document which you want to execute outside India, which you could have done it in India, that means in short, the consulate office or the embassy or high commission is a part of India and you are in India over there and you're executing the document. That authority is given to the consular officers under 1948 Act. So if a person goes to a local notary and sends that notarized document in India, then it is not acceptable because it is not in accordance with Section 3 of this 1948 Act.
Okay. Sir, is there a concept of irrevocable power of attorney?
Yeah, there is the concept of irrevocable power of attorney. That means revoked means to cancel, to withdraw. As I explained earlier, if the power of attorney is executed with a stamp duty as applicable to a conveyance, then such powers of attorneys are irrevocable. That means cannot be cancelled. Take the situation. A wants to sell the property to B for 1 crore. B has paid 1 crore to A, and A has given a power of attorney to B. Now, this power of attorney has to be on a stamp paper of rupees 7 lakhs if executed in Maharashtra. So, accordingly, A has given the power of attorney to B, and B is having the possession of the property, and B has the power of attorney on the strength of which he can purchase the property in his name, or he can sell the property to C any time in future. After having received 1 crore from B, if A says that the power of attorney is cancelled, revoked, then what will be the situation? What will be the fate of that 1 crore being paid by B to A? Obviously, B will be in trouble. So that's why whenever a power of attorney is executed with a stamp duty applicable to a conveyance, such powers of attorneys are irrevocable or cannot be cancelled or cannot be withdrawn.
Okay. So we have many queries which have come. Should we take a few more?
Yes. If it is typed, it will be better to go through it rather than probably listening may pose a problem to me also.
Okay. So many people are asking the query, is the law of limitations applicable here? Probably you have answered that.
Yeah, I answered that. That means
So
power
one
of
small
attorney can be
question.
power of attorney can be 5 years, 10 years, nothing like that.
So can a power of attorney holder create a will?
Can a power of attorney holder create a will? Answer is yes, if so provided in the power of attorney, but it should not be given such power, because if the person who wants to make a will, he should make the will on his own, because it is his property to whom to be given. It is his prerogative, privilege. Suppose he wants to give a certain immovable property to A, and on the strength of power of attorney in the name of B, B gives the property to someone else, then there'll be huge problem. So although theoretically it's possible, practically it is not advisable allowing another person to execute a power of a will on the strength of power of attorney.
Right. So another question, can a power of attorney delegate it to someone?
Can a power of attorney
Delegate to someone? I
give?
think the person is trying to say, if I have a power of attorney, can I again give a power of attorney to somebody else?
That's why I told you, it is delegation of further. There is a specific provision in section 2 of the Powers of Attorney Act. However, the original power of attorney must have a clause allowing him to give the power of attorney further. So if A has given the power of attorney in the name of B, and B wants to give power of attorney to C to act on behalf of A, such power must be there in the power of attorney given by A to B. But if there is no such power and B still gives the power to C to represent A, then later on A can deny the acts or things done by C because he has not authorized to give further power to any other person. But such delegation is possible under section 2 of the Powers of Attorney Act 1882.
Correct. So the question is related to the booklet.
Members are saying, by when will the booklet be available to us?
Now, on the basis of your feedback, any additional thing that you require to be included, any format you would like to, you have got a unique one, can send it to CCLA, or you may have my email ID. On that, you can send it to me. I will include it in the booklet. Then it will be finalized. And as our CCM has told in his inaugural address, that they intend to publish it in the month of May. It will be more of a template. Again, the request is, do not use the templates as a fill in the blanks. Read your own requirements and draft accordingly. It will help you, but it will not substitute your thinking. So you have to draft your own power of attorney, but that will assist you. So don't use it as a fill in the blanks. The institute says that it will be published in the month of May. So on the strength of, for example, one has raised the issue of limitation that I had not included in it. There are another two situations like irrevocable power of attorney or a power in the event of death that was not included in the original booklet. That certainly I will add it based upon your feedback and based upon your suggestions.
So I think we'll take one last question. If a power of attorney is executed, paying the applicable stamp duty of conveyance, will it become irrevocable on all circumstances?
Will it become
Irrevocable on all
if the
circumstances?
power of attorney is executed on a stamp duty as applicable to a conveyance, it will be an irrevocable power of attorney. But if it is executed on a normal stamp paper of which 500, etc., depending upon the local laws of the state, then it is revocable. On the death, it will get cancelled automatically, or it can be withdrawn also by the donor.
So we had total around 24 questions with us, but most of them were repeated. In fact, 27 questions were there with us, but most of them were repeated. So I just clubbed it and asked it to you all. I think one more we've got now. Irrevocable power of attorney as conveyance vests or provide mechanism of transfer of property. In that case,
Yes.
will clause should be included?
See, when you are giving authority to transfer a property in your own name or in the name of any other person, so when you give a power of attorney for transfer of property, you describe the property, you describe to whom it is being sold. So that means these normal clauses are there. I'll just read out in case of a power of attorney executed outside India. Just the executant, that means the donor, desires to sell his one-half share in a residential flat in India, more particularly described herein below. That is flat number, in building number, on second floor, third floor, etc. address, to XYZ, if they are known to you. But if you want to include it as a power of attorney in the name of buyer himself, which he can take it in his name or anytime in future to someone else also. Now what it says, the executant is permanently residing out of India at so and so place in USA. Therefore, this power of attorney is being executed at the Indian Embassy in New York, etc. It is not possible for the executant to comply and execute required acts and deeds and things and formalities in respect of said flat intended to be sold. Therefore, the executant decided to appoint brother-in-law of his mother in India, a resident of so and so, as an attorney on behalf of, for performing the below mentioned acts, deeds, and things. Then there is a list of things that can be executed. That means here you have to, whenever you want to give a power of attorney for transfer of property, it is must be registered as per the requirement of 17(1)(a) of the Indian Registration Act. Then it cannot be general power of attorney. It has to be a special power of attorney. That means you have to describe the property which you intend to sell. If you are giving the power of attorney to a near relative, it must be registered. Then in that case, it can be executed on a 500 rupees stamp paper. I am speaking about Maharashtra only. I am not aware about other states. But if the power of attorney is to be given to outsider, that means other than relative, then it has to have a stamp duty as applicable to a conveyance. Now this stamp, even this stamp power of attorney must be registered. Now it can be registered in India. That means whenever the person is in India, a foreign person that is non-resident Indian, whenever he comes to India, he can do the registration in India. Then there is no requirement of going to the consulate arises. The requirement of going to the consulate is there only when the donor cannot remain present in India. So if he is there in India for signing the documents, the sale deed, etc., no power of attorney is required. He is absent from India, then he should give power of attorney while he is in India, and that the power of attorney must be registered. But he cannot come to India even for giving the power of attorney or for execution of the transfer documents. Then he has to go to the Indian consulate or embassy, as the case may be, and do the registration, do execution of the power of attorney, and that can be sent to India to the donee, and then donee can act on behalf of donor for the transfer of property.
Okay. So, permission, I'll take one last question. Should I?
Yes, go ahead.
So where 4 persons have executed a power of attorney, which is irrevocable,
Is it?
and 1 person expires, can the power of attorney be continued by the surviving members?
See, what is the, is it a transfer of property with full stamp duty? If
Sorry, sir?
there are 4 persons who have executed a power of attorney in the name of a buyer, or and they have got the consideration, and one of them has expired, since it is the power of attorney executed as if it is a conveyance, it becomes irrevocable. That means even a death or otherwise, the power of attorney continues because he has paid full stamp duty as applicable to a conveyance on that power of attorney. But again, I am repeating that this is the provision as I know in the state of Maharashtra. Other states may have different provisions with respect to execution of power of attorney on this particular issue.
Correct. Great, wonderful, sir. We had more than 30 plus questions today, and it was really a wonderful session, sir. You covered this power of attorney sections in detail. Probably even I was not aware that power of attorney is really so much important, and the seriousness of it is now understood actually. Because somewhere like as you mentioned, if we have a DSC of the client, we have to take a power of attorney for it. So probably such things have to be seriously taken care of, and definitely the other points were also covered very very well. And I'm sure it is understood by all the audience, all the participants here. And the booklet, which actually is the contribution made by Sharad Vardhi sir, will definitely clarify your doubts, and you will come back to the book again and again in case if you have doubts in the future as well. The booklet will be published soon, probably the next month it should be there, and it will be a guide with you throughout.
Moushmi, you can just add my email ID sharadvardhi@gmail.com. So if anybody wants to give their specimen, or if anybody wants to add something which was not covered today, we can think of including that aspect in the booklet also. So shall I
Okay.
write my email ID over here?
Yes, sir, please.
But let us take it that it should be before this month end, because we must give some time to the institute for its publication. So let us say that by 30th April, if you send me anything you want to ask, anything you want to include in the booklet, let me know, or anything which is not covered today, now you have realized it, let me know. I'll try my best to include in it so that the book will be a thorough book, a complete book. Thank you very much.
We request all the participants to please send your feedback or queries at sharadvaze@gmail.com. This is sir's email ID, sharadvaze@gmail.com. So for any queries or feedback or any inclusion that you want us to make in the booklet, please give us your comments. So again, sir, thank you for this wonderful and in detail session on forest photography. Thanks a lot. Fortunate to have you here with us. Thank you again.
Thanks.
Thank you. Yes, yes, please. Thank you, everyone.